your Lordship and participants. Welcome to the 5th Dr. B.R. Ambedkar National Moot Court Competition. I will briefly apprise you of the rules of shall any speaker disclose their identity or that of their institution. Only one speaker shall be permitted to present rebuttal or surrebuttal arguments. Also please note that I shall indicate the time by tapping once when 5 minutes remain and twice when 2 minutes remain and thrice upon the completion of your allotted time. The researcher shall not be permitted to address the court during the proceedings. However, they may assist the speakers by passing written notes if necessary. In the event that a speaker continues beyond the allotted time, such extension shall invite negative marking subject to the discretion of honorable judges. Now, with the permission of your Lordship, may we proceed the competition?
The council seeks the permission to approach the dais. Much obliged. The council further seeks the permission to collectively address the bench as my lords and your lordships interchangeably. Grateful, my lords. The council is representing the petition of my lords in this instant case of State of Punjab versus Amit Sharma and another before this honourable court, my lords. And the council humbly submits to the jurisdiction of this honourable court under Article 136 of the Indian Constitution, my lords. My lords, if I may just make one mention, if my lords could excuse us for we do not have a third member, our researcher is not present. I actually had some family notes. Grateful, my lords. My lords, this case is inevitably the epitome of scrupulous litigation wherein the respondents themselves have not come with clean hands, my lords. And I shall elucidate this further, my lords, in my arguments. If I may just briefly apprise my lords of the allegations qua the respondents, my lords.
Yes.
Grateful, my lords. My lords, as far as respondent 1 is concerned, my lords, the respondent 1 was connected through to this case, my lords, by the fact that his number and mail ID was found in the recovery mail ID number of the account's PGF account, my lords, which is the main instigator in this present case, my lords. And I'll come to how they have instigated, my lords. Correspondent number 2, my lords, it is prima facie evident that he himself has admitted that he's made the content and the remarks, my lords. Therefore, now, my lords, coming to the fact what has led to this case, my lords. The offence, my lords, it is the PGF, my lords, it is the Punjab Justice Front organization which undertook a digital entity, my lords. And this is when the agrarian protests were going on in December 2024, my lords. Now, my lords, if I may bring my lords to the Moot proposition itself, my lords. Can I have my lord to the Moot proposition, my lords, if it is present? The Moot proposition, my lords. Do my lords have that?
Yes.
If my lords could directly come to paragraph number 4 of page number 1, my lords. Paragraph number 4, my lords. Page number 1 of the Moot proposition, my lords. I believe this is the petition that we've submitted, my lords, of the Moot proposition, factual sheet, my lords.
Have you submitted any such report along with your charge sheet to the court?
My lords,
Charge sheet has been submitted with your police report,
my lords,
right? Along with that, there is a section or not in that charge sheet, along with that charge.
Is it there with my lords? The first page, my lords, the very first page, paragraph number 4. Yes, my lords, this, my lords. Am I with my lords on paragraph number 4, my lords? If I may read for my lords' consideration, my lords, it says the PGF channels disseminated, my lords, which is spread information, and it is through this channel that the respondents are related, my lords. First, allegations of institutional persecution of specific groups, my lords. This prima facie indicates that here in the PGF channel, my lords, had undertook the image, the photograph of a serving IPS officer, my lords, took his name, my lords, and represented themselves to the public as the ones who will be giving insider information of the state administration, my lords. Therefore, my lords, impersonation is clearly established here, my lords. Second fold, my lords, is that it is through this channel, my lords. The second information what they had called for was call for mass civil disobedience, including refusal to comply with lawful government orders, my lords. Given the fact that respondents themselves are not coming out to show their individuality, my lords. They've hidden under the garb of a serving IPS officer, my lords. And they're trying to deceive the public, my lords, to the effect that we are the ones who have the inside information of the state administration, my lords. And my lords, how is this?
Is there any particular section which you have imposed on them for criminal impersonation?
Indeed, my lords, it is, my lords, section 66C and section 66D, my lords. My lords, in fact,
Is there any section with IPC? These are the sections of IT Act. Is there any particular section dealing with impersonation in IPC?
my lords, if I'm able to understand the query put forth by my lords, is that whether any section of IPC has been arraigned.
Whether any particular section dealing with criminal impersonation in general?
Indeed, my lords. My lords, the council please acknowledge to this fact the council is restricted to the FIR at the present.
You are
Indeed.
contending that impersonation has happened.
Indeed, my lords. And my lords, for the fact, my lords, it has been done digitally, which is why the Information Technology Act has been invoked. And my lords, to that effect, my lords, there are four considerations which have been canvassed, four issues which have been canvassed for my lords' consideration. The first two particularly deal with the quashing of FIR, my lords, and whether the prima facie offences are made out or not.
Are you dealing with issue number 1 and 2?
Indeed, my lords.
Please proceed.
First two, indeed, my lords. My lords, the very first issue indicates whether, and I will disseminate, I will show how the impugned judgment in question, my lords, how is it perverse in law, to the effect that it had quashed the FIR, my lords, at the initial stage, at the very nascent stage where investigation was ongoing, my lords, and that is particularly the issue before my lords. Given the fact, my lords, this is not a normal crime, my lords. This is a complex digital cyber crime, my lords. And if my lords could have the scale of this crime, is that, my lords, the information spread was to.
What are the prima facie evidence you have?
Indeed, my lords. My lords, as reiterated before, my lords, it is the PDF channel which is the root cause, my lords. And it had called for civil disobedience, my lords, to lawful government orders, my lords. Number one, my lords. Second is, my lords, that they have been alleging that there has been institutional discrimination of specific groups, my lords. Not one group, specific groups, my lords. And all this information is not just criticism, my lords. It is being spread on the pretext of showing themselves as a part of the state administration, my lords. And it is evident, my lords, on record that the insignia of Punjab police has been used, my lords. The photo of serving IPS officer has been used. His name has been used, my lords. And my lords, if my lords could see, it is on record that the information was algorithmically spread, my lords. And it is not normal information, my lords. It is information or content related to unrest, my lords, which is again given, my lords, on passage number 2, my lords. It is prima facie evident that he himself has admitted that he's made the content and the remarks, my lords. Therefore, now, my lords, coming to the fact what has led to this case, my lords. The offence, my lords. It is the PGF, my lords. It is the Punjab Justice Front organization which undertook a digital entity.
Parameters, counsel, like to amplify any video or image, and are there under control of the petitioner or the respondent in your case?
Indeed, my lords. If what I've understood is that my lords are asking how are the respondents.
See, this is my simple question. If something goes viral,
Right, my lords.
and you have whether you have any control on something going viral or you don't have any control on something that is going viral.
Indeed, my lords. My lords, if I could answer that, my lords, it is very well present in the factual substratum itself, wherein it is the facts on record which clearly show that it was not natural for the content to go viral, my lords. It was intended by the respondents, my lords. It says algorithmically amplifying unrest-related content, my lords.
So algorithm is always with the digital intermediaries, not with the petitioner or the respondent or the accused in your case.
Grateful for that observation. I bow down to that, my lords. If my lords could just consider one background fact of respondent number 1, my lords. The fact that respondent number 1 is not a layman. He is a digital analyst, my lords. He is well versed with computer and digital domain, my lords. And secondly, respondent number 2 himself is a content creator, my lords. Therefore, these background facts really need to be considered, and it is only in these lights that the state is contending the arguments, my lords. If I've sat, yeah.
Basically, the thing comes down to the algorithm is beyond the parameters of content creators. Algorithm is mathematical and it has to be calculative in computing language itself. So, do you contend that they know the computing language to that extent of creating an algorithm?
Indeed, my lords, indeed. It has already fallen from the court, my lords, itself, my lords, that these are, again, as reiterated before, my lords, these are no layman persons or the ones who are uneducated, my lords. It is evident to the fact, in fact, respondent number 1 is working in a multinational company, my lords.
Does that make him an expert in algorithm?
My lords, this is what the council is indicating for the fact, my lords, and it is not only on this factor alone that the council is contending, my lords. It is one of the factors that needs to be considered, my lords. It is in this light that may be seen that they have algorithmically amplified this data. And if my lords could see in what situation, it is the agrarian protest at the peak, my lords, and in which areas have they amplified, my lords. It is the border districts of Punjab, my lords, which have a history of sensitivity, my lords.
Counsel, why you have not made the digital intermediary a party to this case? Why selective persecution against these two individuals who have probably nothing to do with the crime or nothing to do with the algorithm which is functioning, or something or somewhere that is being manipulated by somebody who is sitting in probably USA or somewhere else?
My lords, if I just beg to differ, my lords, to the fact, my lords, if I could elucidate how the allegations have been put forth qua the respondent itself, how they are connected with the PGF itself. If that can satisfy, my lords, right? If I can make those arguments, my lords. Grateful, my lords. My lords, qua respondent number 1. My lords, if I can take a hypothetical situation for a moment, my lords. My lords, it is on record that 3 accounts of PGF were made. My lords, on Instagram, Twitter, and my lords, Telegram, my lords. Qua respondent.
Counsel, are we discussing hypothetical situation or on record?
My lords, on record, this is on record, my lords. The fact that these accounts were created, and my lords, whenever one individual creates an account, there is a recovery email and number which every account asks for, my lords. And the recovery email and number was put off respondent number 1, my lords. Now it is it is contended by the respondent number 1 that it was due to his data breach that his that his number was found in recovery email and number, my lords. But to that effect, my lords, the respondent has nothing to show on record whether he had filed any FIR complaint, my lords.
This is what we are saying, that you don't have any prima facie case against these respondents or accused which you are making. You are just alleging what they are alleging against you. They are saying that it is a gag order. You are gagging the dissent they are having against the legitimate or illegitimate ideas of the state. This is a political dissent. This is what they are alleging, and they are only reporting what is happening in the ground. They are nothing. They are doing nothing else.
I bow down to that, my lord, but I'll again beg to differ on that fact per se for the reasons, my lord, in twofold. If I could answer that in twofold points, my lords. The very first point is that, my lords, when one criticizes somebody, my lords, it is if I were to criticize the government or any order, my lords, I will criticize on my face value, my lords. I will not impersonate or make an account of a serving IPS officer, my lords. The fact that he is still serving in the government, my lords, a serving IPS officer using his name, my lords, using the Punjab police insignia, my lords, and then it's not that I'm just criticizing, my lords, I'm calling for disobedience of lawful government orders, my lords, and then alleging on behalf of the state, my lords, as an insider to state administration, that there has been discrimination, particularly by the state, to certain specific group, my lords. And this overall, my lords, in the limited knowledge and experience of the council, creates a prima facie case. And my lords, I may not show light to the sun. My lords are very well aware of the fact that while dealing with the quashing of FIR, the threshold is very different that from a trial, my lords. While listening to a case of quashing of FIR, my lords, the courts are to only consider, very humbly stating this, my lords, with all humility, that courts are to only consider whether there is, whereas there is only commission of offence which can be read out, my lords. And it is very evident, my lords, in this case. if I'm able to satisfy my lords with that issue.
See, whatever the state does, it has a chilling effect of on everybody, which is, probably they are protesting in a civil manner. This is what you are alleging, that they are protesting in a civil disobedience. This is what they are, justice they are seeking. So if a party is doing something for justice, that's why the protesters are protesting there, right? And we are taking no action against the protesters. But you have selectively targeted these two individuals who were, probably reporting, and against it, they were reporting what is happening in the ground.
My lords, if I could just again beg to differ to the fact, my lords, that the protesters are protesting physically as themselves, my lords. They're not impersonating anybody, and my lords, it is not impersonation of just any random individual, my lords. They're portraying themselves as insiders of state administration, my lords. And my lords, this is not what the state is alleging, it is on record, my lords. The factual substratum says that itself, my lords. It is the PGF that themselves have admitted to the fact, my lords. And Quad respondent number 1, if I have satisfied my lords, Quad respondent number 2, if I can come to that, my lords.
Number 2.
Respondent number 2, my lords. Now to that effect, my lords, respondent number 2, he himself has claimed that he was the administrator of Telegram channels, my lords. And he is just challenging the constitutionality, in fact, of these provisions, my lords, coming under section 528, my lords. And therefore, the prima facie case is clearly established, my lords. And if, my lords, if at all it is contended by the respondents that there was no mens rea, my lords, or there was no overt act in the sense that violence had not occurred, my lords, if I may humbly submit, my lords, these provisions of section 196 and 299 DNS, my lords, they need not have an effect, they need not have an violence occurred, my lords. They can have, they seem to be a preventive measure, my lords, and this has been ruled by my lords itself in the by this honorable court, my lords, in the case of Amish Devgar versus the Union of India, my lords, wherein these provisions have been held to be used for propensity, my lords. And my lords, to that effect alone, a prima facie case is established, my lords. If my lords are satisfied with that, to that effect, my lords, and my lords, if I could just make another mention, that it was when the quashing petition had been filed by the respondents in the Honorable High Court, my lords. While the petition was pending, my lords, charge sheet had been filed. And charges were also framed, my lords. And the impugned judgment did not even consider that charge sheet had been filed or charges were framed, my lords. The Honorable High Court, in its wisdom, my lords, restricted itself to stating that investigation cannot be carried forward on the pretext that it will violate Article 21, my lords. If the Honorable High Court ought to have quashed the FIR, in its wisdom, my lords, it ought to have considered that charges were framed, my lords. There was prior judicial application of mind, my lords. The trial court had made evidences put forth in the challan by the police.
There is a difference between investigation, trial, and then comes the judgment. So FIR was quashed probably before the trial even began.
Indeed, my lords.
Now my question is, when does the trial begin?
My lords, in the limited knowledge of the council, the trial begins, my lords, when the charges are framed by the trial court, my lords.
One second. So you yourself, just said that evidence was evaluated.
My lords, to the effect that challan had been presented and the trial court found some substance in those investigating evidences collected by the police that
Charge sheet, the concept charge sheet is presented by the police.
Indeed, my lords.
The trial court frames charges.
Great.
Charges are not yet framed according to your new proposition.
If I could bring my lords to the second page of the Moot proposition, my lords, please. Second page of the Moot proposition, my lords. My lords have it, second page. If I could bring my lords to the 10th point and the last paragraph. 10th point and last paragraph. I believe my lords have already read it. So my lords, charges had already been framed and the High Court in its wisdom did not feel relevant to even give its opinion on the framing.
Counsel, can you point out where it says the charges are framed by the trial court?
Indeed,
In the Moot preposition.
Indeed, my lords. My lords, if just before the 11th paragraph, my lords, the very last line, if I could read that for my.
But also paying
Am I one with my lords on that issue per se, my lords, that charges were framed, my lords, if my lords are satisfied with that? Therefore, my lords, the High Court erred in not considering, my lords, and given the fact, my lords, that this is a complex digital cyber crime, my lords. And my lords, I derive institutional persecution of specific groups, my lords. This prima facie indicates that here in the PGF channel, my lords, had undertook the image, the photograph of a serving IPS officer, my lords, took his name, my lords, and represented themselves to the public as this argument, my lords, I derive strength to this argument from the fact that it is only this honorable court itself, in the case of Padnaya Pranjal Kulkarni, was in the state of Maharashtra very recently, my lords, in the year 2025, had adjudged that if the FIR is to be quashed, my lords, given the fact when charges are already framed, when the trial court has applied its judicial mind, the courts need to be even more cautious, my lords. And again, my lords, the threshold standard is not of a normal criminal trial, my lords. It is only the prima facie evidence that needs to be seen, my lords. And here in the present case, my lords, I believe it is even beyond prima facie evidence that links the respondent number 1 and 2 to the PGF and then in turn to the FIR, my lords. Indeed, my lords. So, my lords, this just to make last submission, my lords, to the fact, my lords, that it is contended by my learned friends from the respondent side, my lords, in the petition as well, that mens rea needs to be considered, my lords. My lords, in the given fact, my lords, again at the stage of quashing of FIR, mens rea does not hold relevance. And arguendo, assuming but not dissenting for a second, that mens rea needs to be considered, my lords. Again, it is evident from the factual matrix itself, my lords, wherein, again, algorithmically they amplified the data, my lords. They could, if it was, my lords, answering to the query put forth by my lords, that it could happen naturally, my lords, by the intermediary, my lords. My lords, if that ought to be the situation, my lords, it could have gone to any other part of the country, my lords. Why was it that during the time of agrarian protests, when they were at the peak, it was only amplified in the areas of border districts of Punjab, my lords, and not to any other border district, my lords, those specifically having history of sensitivity. My lords, these were the submissions.
Issue number 1 you have covered, or both the issues you have?
My lords, I've tried to cover both issues, my lords, considerably, because both the issues related to quashing of FIR, exceeding of jurisdiction by this honorable court, my lords, apologies, by the High Court, my lords, and whether prima facie offences of 196 and 299 are made out of law. And my lords, in the last, I will just pose a question to myself that 528 BNSS, my lords, which says that the honorable courts can go to the extent of wherein they have to meet the ends of justice, they can pass any order, my lords. Now, my lords, with offences alleged, my lords, that the investigation may not even be carried, my lords. Therefore, my lords are satisfied. May I call upon my co-counsel for further arguments, my lords?
I'd just like to ask. So you allege that the High Court's in proceeding to quash the FIR was not justified.
Indeed, my lords. Indeed, my lords.
So do we perceive that the High Court is not comprising of a competent bench who could analyze the situation to come down to a conclusion?
My lords,
What could be the vision of the High Court in proceeding to say that the FIR is to be quashed?
my lords,
As per your allegation, you say that it should not be quashed. So
My lord-
what material evidence you want to specify?
My lords, grateful for that observation, my lords. To the extent, my lords, it is to answer the first part of the question put forth by my lords is that, my lords, the council is nowhere contending the wisdom of the high. Indeed, grateful for that, my lords, grateful for that, my lords. For the fact that, my lords, Punjab and Haryana High Court itself has been a torchbearer in cases of cybercrime, my lords. Therefore, given the context, my lords, and prima facie evidence, my lords, it is of course, my lords, quashing of FIR, the court cannot sit to weigh evidence, it cannot go to the merits, it only has to consider FIR as the gospel truth. Therefore, my lords, it erred in quashing the FIR given the scale of the offences alleged, my lords. If I am able to answer to the query put forth by my lords.
So it was actually a pre-charge. It was a pre-stage.
My lords, the issue framed was that whether High Court was justified or has exceeded its jurisdiction while the quashing the FIR, the nascent stage or the pre-charging stage. But in the meanwhile, my lords, while the question petition was pending, charges were, the challan was presented and charges were also framed by the lawyer.
All right.
Grateful, my lords. It was an honor assisting, my lords.
The council seeks permission to approach the dais. May it please your lordships, the council will be dealing with the third and the fourth issue limb-wise. May I, your lordships? Grateful. My lords, the third issue pertains to whether sanction under section 217 BNSS is a prerequisite for investigation or a loan for cognizance. Now, my lords, the first limb revolves around establishment of the difference between investigation and cognizance. Now, my lords, cognizance is a judicial act where a magistrate applies their mind to a case, whereas investigation is an executive function of evidence gathering. If my lords may permit me to read section 217 for your lordship's reference. My lords, may I just read the effective part? No court shall take cognizance of any offence punishable under section 196, section 299 or a criminal conspiracy to commit such an offence except with the previous sanction of the central government or the state government, my lords. Now, my lords, this particular section is unambiguous and is inclusive of everything. It states that no court shall take cognizance. It does not say no police shall investigate or no FIR shall be registered. Now, my lords, this very honourable court in state of Karnataka versus Pastor B. Raju in 2006 held that the statutory bar is strictly against the court taking cognizance. There is no bar against registering a case or conducting a police investigation without sanction, my lords. Now, my lords, a valid sanction is not merely a paper formality. It requires the government to review the investigative material to decide if a trial is necessary, my lords. Now, my lords, if a sanction were required before the investigation, it would put the state into a paradox. The police would require sanction before investigation, and the authorities, central government or state government, before giving out the sanction, they would require some material to judge that the sanction is required or not, my lords. This would create.
Okay. Have you submitted any such report along with your charge sheet to the court?
My lords,
Charge sheet has been submitted with your police report,
my lords.
right? Along with that, there is a sanction or not? In that charge sheet, along with that charge sheet.
My lords, the present factual matrix is silent on that fact, and if it is assumed that the sanction was not pertained, it can also be assumed that the sanction was pertained, my lords. The current factual matrix is silent on that, my lords. May I proceed? Coming back to the point that it would create a situation, if the sanction is required before the investigation, it would create a situation where the cart is put before the horse, my lords. Now, my lords, the second limb of my argument pertains to the fact that since the charges were framed during the pendency of the quashing petition, it was necessary for the accused respondents to challenge the framing of charges, my lords, in order to obtain a stay or to have the High Court judge on that particular fact, my lords. Now, my lords, the mere framing of charges by the magistrate shows that there existed a prima facie case against the respondents, my lords. And the High Court has erred in its findings regarding the same. Now, my lords, it is admitted that the FIR also pertains to the offences of Section 66C and Section 66D of the ITR. Now, my lords, both of these offences are cognizable in nature, do not require any sanction. So, my lords, this honourable court, in plethora of judgments, has held that where an FIR discloses multiple offences arising out of the same transaction, and even one of those offences is cognizable and requires no sanction, the police have an unfettered right to investigate the entire case, my lords. Now, my lords, the third limb of my argument pertains to the introduction of a modern safeguard by the BNSS as per Section 173, Subclause 3. My lords, it provides for pre-investigation inquiry. My lords, for offences punishable between 3 to 7 years, this particular section allows a preliminary inquiry to be conducted within 14 days with a DSP level approval, my lords. So now, if my lords may permit me to pass on a judgment. My lords, may have the second page, internal page 70. The relevant portion has been highlighted. My lords have it. The registration of FIR is mandatory under Section 154 of the Code, that is 217 of BNSS, if the information discloses commission of a cognizable offence, and if so is done, preliminary inquiry is not permissible in such a situation. My lords, if the information received does not disclose a cognizable offence but indicates the necessity for an inquiry, a preliminary inquiry may be conducted, my lords. It is a discretionary power over the police officer, my lords.
Counsel, when you have registered an FIR, you have already, went way ahead from the preliminary inquiry. Is it so?
My lords, very grateful for that.
What's the point of contention here regarding the preliminary inquiry?
Very grateful for that observation. My lords, the council is just trying to establish the fact that in this particular case, cognizable offence was their prima facie, meaning thereby that no preliminary inquiry was necessary in this case. My lords, the Supreme Court, even in Lalita Kumari, my lords, while laying down the guidelines for the FIR, it stated that if the information received discloses commission of a cognizable offence, then no preliminary inquiry is permissible. My lords, the scope of preliminary inquiry is not to verify the information received, but only to ascertain whether the information received discloses any cognizable offence.
Counsel, if this appeal is allowed, then isn't it like allowing the state machinery to arrest every news reporter as well?
My lords, news reporter do not, very grateful for that observation, my lords, but the news officials, they do not impersonate a state authority, an official authority.
If they are seeking their relief or they are seeking justice from a particular part of the state machinery, that's why they are using probably their insignia. So their main grievance is against that particular authority. Even if they are using it, so I have seen personally in my life, I have seen so many protests where they are using the posters of Narendra Modi or probably Indira Gandhi as well, the then Prime Minister of India, or probably protests are also going on against Bhagwant Mann as well. So isn't it their main grievance is against that person? That's why they are using it. This is what their protection is.
Lordships, that would, for example, if a few of my friends, we gather together and we print out some posters of Punjab police and go around
towards the citizens of this country, and we are talking here only about all the sensitive areas which is concerned, border areas probably.
Your Lordship, in our countries of democracy, the respondent, they are only creating content and they are sharing their views and political dissent. And if it is also considered as an offense, then no person will go against the state and no person will.
That's why we have so many people protesting against, and we have taken no action against them, but we are taking action against only two individuals which were first amplifying for their own benefit. Protests are going on. We have nothing to do with that protest. This is what democracy is. You can protest,
Yes, Lordship.
but you cannot use somebody else's protest for your own favor or to create a public situation that where everybody is unsafe.
But Your Lordship, that is not establishing the facts that the account was created by a respondent and they were doing and they were responsible for calling for institutional persecution or calls for civil mass disobedience. It was done by PGF channels, and there is no nexus between that respondent number 1 and respondent number 2 have established these channels, or these are administered by them.
Counsel?
Yes.
How do you relate with this state of Karnataka L. Muniswamy to your case? Second question.
Yes, Your Lordship. Your Lordship, in this case, it was held that High Court can quash a proceeding if it considers that it will that continues.
I would interrupt the counsel. The High Court is entitled to quash proceeding if it comes to the conclusion that online the proceeding, we are talking about investigation. Over here it is about session court's proceeding that were halted. Go to the previous para.
Yes, Lordship.
The section is contained in chapter 18 called the trial before courts of session. It is clear from the provision that session court has power to discharge. This is in regard to the discharge. How it is relevant to your case?
Your Lordship, Counsel knows are not aware about it, Your Lordship.
It is your judgment, counsel.
Yes, Your Lordship.
You have cited it previous para. You have not read it.
I would plead ignorance, Your Lordship.
Going forward with that, session court has power to discharge an accused if after pursuing the record and hearing the parties, he comes to a conclusion for reason to be recorded that there is not sufficient ground for proceeding against the accused. This is the observation of the sessions court during trial of the discharge,
Yes,
and which has been confirmed by the Honorable High Court later stage.
Here you are at a pre-trial stage, just FIR, no?
Yes, Your Lordship.
So we did not go up to that stage only, right? So
Yes, Your
referring to that is not relevant for the current, right?
Yes, Your Lordship. Shall the counsel
Proceed.
Your Lordship, in the present case, High Court's observation that digital footprint alone is insufficient to infer mens rea is not an evaluation of evidence, but a legal determination that the essential element of criminal intent is not established. Without mens rea, the offences alleged cannot be sustained, and therefore the continuation of proceedings would be legally untenable. Your Lordship, the continuance of criminal proceedings in absence of prima facie case would result in violation of respondents' fundamental rights under Article 21 of the Constitution, and it has been held in Century Spinning and Manufacturing Company versus State of Maharashtra. And the Honorable High Court clarified that if on the existing material there is no ground of presuming them to be guilty, then there can be hardly any point in framing charges and going through a formality of trial and acquitting them. Such a course would merely result in unnecessary harassment to the appellants without serving any cause of justice. And Your Lordship, the present case, the complexity of cyber offences does not preclude judicial scrutiny. Complexity is not a substitute for presence of prima facie material establishing any statutory element against the accused. The mere existence of digital transactions or online activity does not automatically imply criminal involvement. In the present case, in the absence of clear evidence demonstrating intentional participation in the alleged offence, the respondents cannot be subjected to criminal prosecution.
Council, what are your main apprehensions from the state?
Your Lordship, the main apprehensions are that
They nowhere states that they are going to arrest you.
yes,
Probably all the offences which they have, charged you against, they all are bailable offences. You are not getting arrested. They are saying that we are registering an FIR and we are supposed to, or we are trying to investigate the matter further. If you are pleading your innocence, this is not the right stage to plead innocence. You can plead innocence in the trial court. We are here not to evaluate even a single piece of evidence against you.
but Your Lordship, the continuance of proceedings with violation of
That is the right of the state to investigate the matter. How can you say continuation of the investigation for offences which are probably I think they are punishable with less than 5 years of punishment is against your fundamental rights.
Your Lordship, it would create a chilling effect on the freedom of speech and
I think it would create a chilling effect on the accused. More? Consider it this way.
See, if we do not permit investigation,
yes, Your Lordship.
right, so then what is to be done? That is the power of the state. So you allege that investigation should not be done, and that is also preliminary investigation. So you, what do you allege? That also should not be done. That violates freedom of speech and expression. How do you interpret that?
So I will simplify the question for you, just for your assistance. So there are 3 pillars on which Indian democracy is working. Are you aware of those 3 pillars?
Yes, Your Lordship.
What are those?
Legislature, executive and judiciary, Your Lordship.
So it's the executive's duty
Yes,
to
Your Lordship.
investigate the matter. It is the probably judiciary's duty to hold somebody innocent or guilty.
Yes, Your Lordship.
So don't you think, if we say we continue with the question of the FIR, we are taking the power from the executive just for being overzealous about our own powers. Though we have powers, but
Yes.
they are to be used in the rarest of the rare case. This is their duty and this is their power to investigate. We are taking that investigation's power from them. That too in the very beginning.
Respondents can be joined as witness in the case.
Are you willing to give a statement that you are willing to join the investigation? Should we reinstate the FIR?
That
Please give a statement.
You want to give a statement in regard to giving a statement against yourself? You are giving up your constitutional rights before the court?
Yeah.
Your Lordship, in order to prove the innocence of the accused, they
Counsel,
can
what is the
be.
duty of the state? 2 words. What is the duty of the state? Why there is that duty? Everything summarized in 2 words. Why the state is doing what they are doing and how they are doing, whatever it is, everything in 2 words.
To preserve the public order and tranquility of the state.
Those are not 2 words. Welfare state.
Welfare state. Yes, Your Lordship.
It's a welfare state. It is working for the benefit for the people by the people.
Yes, Your Lordship.
So where is the welfare when they stop registering FIRs? Where is the welfare when no FIR will be registered and every time constitution provisions of right to freedom of speech will come in?
However, Your Lordship, if FIRs are registered for every case which is not prima facie established, then no person will speak against any unlawful thing also of the government, and it will create a dictatorship of the government.
So that implies, right? You
But
have to.
registration of FIR means the dictatorship of the government is decreased by that.
No, Your Lordship.
Where FIR is to be registered? Where when it is to be registered, how it is to be registered. When you are talking about it, we have also to look at the side of the accused as well as the victim.
Yes,
Right? State is addressing everybody, that is why sir used the terminology welfare state.
Yes, Your Lordship.
So, you know, if you are aware of the recent blast that happened near, I think in Delhi, Red Fort, near Red Fort, right? So, what if you as a state are given particular inputs that something is going to happen? You don't know how it is going to happen, but something is going to happen on this date. What should the state do? They should immediately arrest those persons,
Yes, Your Lordship.
right? And how can then they see your argument solely revolves around that ground that we are innocent and we are not doing things they are alleging. So if given a chance that you can prevent something like the Red Fort blast, will the state do it, or they'll shy away that let it happen first and then we'll start our investigation?
Yes, Your Lordship, the state will do it, but it depends on whether the threats are.
So you use the term dictatorship. So we have taken zero action against the people who are protesting against the state. We are particularly taking action against these two respondents or individuals, which we apprehend that using those funds for their illegal means, whatever however they do, or whatever things they are planning to do. And this is a country where criminal conspiracy against the state is a punishable offense.
Yes, Your
If you are caught doing conspiracy against the state, you can be caught and prosecuted. Are you aware? Like there are so many laws which are dealing with the present moot court preposition, and so many live examples of people who are actually suffering.
Yes, Your Lordship.
So this is the scale of Statue of Liberty has not the Statue of Liberty but the Statue of Justice. We have to weigh down either these two individuals or probably a bigger offense that can happen because of these things.
Yes.
That too in a border state. Please go ahead.
Your Lordship, should I start with issue 2?
Yeah.
The issue 2 concerns whether the allegations, if taken at face value, disclose the commission of an offence under section 196 and 299 of the Bharatiya Nyaya Sanhita 2023. Your Lordship, section 196 relates promoting enmity between different groups on the grounds of religion, race, etc., which requires a high threshold of intent and effect. Your Lordship, there is absence of specific groups in this case, as the entity Punjab Justice Front was created for an agrarian cause, and it was not attacking any specific religious or racial group, and political license in government policy does not equate to communal harmony, Your Lordship. And there was lack of incitement in this case. The material was merely political dissent. The content did not specifically urge one group to attack the other. The face value of the allegations merely showed the disagreement with the state. And in the case of Kedarnath Singh versus State of Bihar, it has been held that freedom of speech includes the right to criticize the government, even strongly. Only speech that incites violence or intention to cause public order can be restricted. Mere advocacy of change or dissent is protected. The court struck a balance between free speech and maintaining public order under 19 clause 2. In this case,
Counsel, sorry to say, but it seems like you are representing the protesters, not the respondents. This is what my observation is. Their observation can be different, but to me it seems like you are for the protesters, against whom we are taking no action.
every council should proceed, conclude the issue 2.
See, what are you alleging? That's what is the contention and how you defend the contention. That is that is what we are interested in. It appears to be moving on the other side.
The judgments and everything we know about.
Yes,
We don't
sir.
want you to read them back to us.
Yes, Your Lordship.
We just want you to let us know how you interpret it and what are you interpreting here in issue 2.
Yes, Your Lordship.
Restricted to that.
Your Lordship, section 196 requires the intent and mensory of the accused respondent, and whereas respondent 1 mere linkage of credentials without proof of control or intent cannot establish the criminal liability of the respondent.
Counsel, proof kahan par hai? Where will the proof come? In the trial? Investigation? Where will it come?
Your Lordship, in the trial.
So you're basically pleading trial over here.
My co-counsel will be dealing with this issue.
The council seeks permission to approach the dais. Can you turn off this? Turn this off. Just turn. Your Lordship, my voice is audible.
Yes.
Your Lordship, the entire arguments of our worthy appellants is based on the contention that PJF disseminated the content. PJF, because if we adhere to point 4 of the factual matrix, it is clearly stated that PJF disseminated false allegations. PJF calls for mass disobedience. Even in point 5, the home report says PJF is algorithmically amplifying the content. However, Your Lordship, in the present case, there is no nexus that has been established between the PGF and my respondents. That is Amit Sharma and Rohan Verma. There is no nexus between them because making a nexus on the basis of the employment that my client is working as a data analyst, so there can be no breach of data. At the same time, if my client admits the content creation, Your Lordship, we have made a petition in the High Court before the beginning of the trial. That means the admission has been made to the police officer that he has been treated with the content. What is the relevance of that admission? Because they have stated that he has admitted the content. So what is the relevance of that admission? It is the matter of trial, Your Lordship. At the same time, if there is no nexus between the two persons, whether they are the part of PGF or not, moreover, Your Lordship, if you adhere to point 2, it has been stated that multiple channels were emerging, pretending themselves to be official state-backed channels. One of the channels, PGF, and from the PGF, only 2 respondents. It seems that state is using its dictatorship to selectively prosecute Amit Sharma and Rohan Verma. And there is no prima facie nexus that has been established except by stating that credentials has been recovered from email, phone numbers. The credentials can be easily can be taken. Why the offense of hacking has been not discovered? It is just because the credentials can be misused. And if yes, Your Lordship.
You're talking about circumstantial evidence.
Your Lordship, I am not.
Circumstances that lead to the evidence, discovery of the evidence, where those evidences are related to you, but circumstantially they are related to you, not directly because you yourself has done something. That is what you are pleading. Circumstantial evidence has been found by the police.
No, Your Lordship, I am not stating the circumstantial evidence. It is the respondents who have backed their entire issue prima facie that my co-counsel, that my clients, that is Amit Sharma and Rohan Verma, they are the members of the PGF. However, there is no evident material in the factual matrix that states that they are the members of PGF. There is nothing on the record that states that Amit Sharma and Rohan Verma, they are.
Counsel, you're pleading more investigation in this regard then?
No,
In
Your
order to
Lordship.
bring it out?
No, Your Lordship. It is not merely because of the. I am contending, Your Lordship, that there has been a selective prosecution.
We will arrest you and we will get your confessions and we will implicate others as well.
More investigation and other channels
Yes.
can also be indicted later.
This is what you have stated that these two
That is
respondents.
why we have approached the Honorable High Court to quash the FIR.
So basically,
Who is
you're
the
not just
investigation.
seeking gag order for yourself, you're seeking gag order for everybody who abused the process of law.
Since not everybody is arrested in the present case, Your Lordship, no.
You have been arrested?
So sorry, Your Lordship, I apologize. Since no culpability has been imposed on any other person of the Punjab Justice Front, only 2 members have been prosecuted in the present case. So we are seeking the FIR needs to be quashed, the investigation needs to be
Counsel,
stopped.
if a WhatsApp group is formulated,
Yes, Your Lordship.
and there are 2 people who are the admins of that group,
Yes, Your Lordship.
and there are so many other participants to that group as well who are not contributing as such.
Yes, Your Lordship.
But these 2 people who are the admins, they are contributing properly. So should there be any difference between prosecution between the admins or the participants, or somebody who are just silently watching, or just being a member of that WhatsApp group?
It can lead to the culpability of those 2 members who are acting as an administrator, but it doesn't really relates to the present factual matters because none of the respondents were engaged as an administrator in the present case. It is just a metadata revealed. What is the significance of the metadata, Your Lordship, on which the respondents are relying on?
Metadata.
Metadata.
Metadata. It carries all the in signatures of the device which was used to create a content. It can be matched like a fingerprint to the other. It can be proven with MD5 hash before the court.
But then, Your Lordship, also, it is a matter of trial in which all these things needs to be
You're
proved.
pleading trial now.
No, Your Lordship, I'm stating that the relevance of that metadata you are stating, it has to be established under the guidelines under the section 65A and 65B of the Indian Evidence Act, which is being replaced by section 62 and 63 of the Bharatiya Sakshar Adhinam, which states that the electronic evidence has to be accompanied with the electronic certificate, which has been mandated by the procedure under section 63 of the Bharatiya Sakshar Adhinam.
That can only happen if police will raid the devices and recover those devices and create a panchnama for those devices and then get a MD5 hash recorded for those devices, bring those devices to the court. But when the devices are in your control, how will police do that without investigation?
It is not stated in the factual metrics that devices are in control, Your Lordship.
The devices are in whose control the devices would be when the content creator is, you're representing the content creator, right? How did you create the content?
Your Lordship, the content is being disseminated on the Punjab Justice Front. It is nowhere stated that the content has been derived from the devices that have been used by the respondent number 1.
That will help, investigation will help in that sense then.
Your Lordship, primarily the dissemination of the content on the online platforms can help the investigation. However, the devices which have been linked, it has to be taken. Again, it is a matter of trial whether the trial court permits the detention of the devices in the custody so that it can be taken into consideration. However, again, the right to privacy is also there, Your Lordship. Again, it is a matter of trial which the trial court has to be considered for appreciating the evidence, whether there is a need for recovering the device of respondent number 2 or not.
But I
Sir.
think- Any-
Right to privacy, what is the restriction for right to privacy?
In the landmark judgment of K.S. Swamy versus Union of India, it has been stated that reasonable restrictions can be applied.